The first one I'm going to start with is Public Records Act. And the Public Records Act case is related to labor because the Court of Appeal was deciding the limitation or the extent, the scope of the personnel rule exception. People can make Public Records Act requests and you must provide it, but how much do you provide if it's something in a personnel file? And so that's why it's relevant to labor relations. One of the members of the Board of Supervisors goes out and starts telling the newspaper every single detail about it and uses words like the diamond earrings were a bribe for the health coverage, the diamond necklace was bribery for the retirement plan, the $5,000, God knows what she got out of them, what they got out of her for that money, and so forth. So the person who's the chief negotiator, who, by the way, by this time, right before her resignation, had been promoted to the HR division director. So she's at a fairly high level. She starts complaining and eventually files a lawsuit saying that they violated their settlement agreement by the Board of Supervisors running around and telling about all these things that were happening. And the county defended by saying, we have a First Amendment right to make disclosures about decisions that we're making, particularly people who are very high-level people like HR directors. And this goes through, and what the court ended up and concluded is, yes, the county had a First Amendment right to tell anything about this story that it wanted to, but it gave that up, it waived it when they agreed to this contract. Either they were going to be in a spot where they had violated their contract and they were sued for a contract violation, or they had waived the free speech rights that they had to go tell stories about her, so they shouldn't have done the severance agreement if they were going to argue their free speech right. If it did not have any of those little sentences that say, except as may be required by applicable law, or to the maximum extent permitted by the law, all of those phrases used in a confidentiality clause bring it within the range of legal. It's not void, it's not a violation of public policy. And the court reasoned this is because if someone had filed a Public Records Act request, you could have responded to it under that phrase that said, except as may be required by applicable law. Unfortunately, no one had put in a Public Records Act request. The member of the Board of Supervisors was just talking without ever having had a Public Records Act request. Tip number one, get a friend to submit a Public Records Act request for you if you're going to, violate the agreement. Tip number two, only give them what they would get under the Public Records Act request, because under the Public Records Act, the person would have requested a copy of the settlement agreement. They could have given the settlement agreement, but the settlement agreement didn't have all this detail about gifts and who met at which restaurant and where the apartment was and all those other little details. So that the rule on this is for the personnel exception, things that are in the personnel file that should be remaining confidential were all these background facts that they had promised to keep confidential. The only thing the Public Records Act would have required them to release was the actual settlement document, and that didn't have any of the stories in it. So basically, the county was in trouble all the way around on this. To keep that separation, that the subordinate can't be the person who provides all the information and pushes the person with the motive can't push it all the way up to the top, and then the top person makes the decision, because if you do that, that is an upstream imputation. That means that basically the person at the top is going to have imputed to them the motives, the discriminatory motives that the lower level person used. She had a journal that she kept on her office computer where she put all of her allegations about people. But she regularly got up and talked in public about how her supervisor named Brown only hired gays and lesbians and favored them for all promotions and various other. Her world theory was more limited, let's say, than most people in HR would prefer. And That upset her supervisor, and her supervisor definitely had a motive to get rid of her if she could. But her supervisor didn't act on it. She was a grown-up, and she just kept saying, I got one in my department, and left it at that. But at some point later, while they're doing a sexual harassment investigation of another employee in another department, they take away his computer and they're looking at his computer for all these things he sent, and they find a copy of Scott's journal, because she turns out to be a best buddy with this other guy, and their viewpoint in the world about pretty much every protected classification, it turns out. And so they see the journal, all this gets handed up to the people at the top. The woman who has the motive to get rid of Scott does not write interview questions, does not select who the investigator is, does not give directions to the investigator. She keeps herself completely separate, like a firewall. She doesn't get involved. And the top person makes a decision that people writing that kind of discriminatory, hostile, negative stuff in a journal and exchanging it on office computers with other employees should be terminated, and terminated her. And that was the protection that they needed, and the person was not found guilty of any discriminatory or retaliatory termination. This was really retaliation for her complaints about her supervisor. Age discrimination. There's two big things going on in age discrimination. The Age Discrimination Act of 1967 has had two big changes this year. One is a U.S. Supreme Court decision that mixed motive shifting of burdens, that McDonnell-Douglas test that everybody learned and has in little charts in your office, does not apply to age discrimination under the ADEA. And secondly, people who can't qualify under the ADEA, the Age Discrimination Act, cannot bring their claims under a 183 federal court case. And this is good because many of you are some form of a state agency. School districts, many colleges, many universities, many transit districts are state agencies. If you're a state agency, the Article 11 of the Constitution, the Immunity Clause, says that you are immune from laws like age discrimination, ADEA, and Americans with Disabilities Act. So employees, to try to get around that that immunity that people who are part of a state agency have, will file and have been filing the cases under 1983. These two standards, they're in two separate cases, are important for defining that. The standard that the Supreme Court said is that the plaintiff has to prove by a preponderance of the evidence that age was the but-for cause of the challenged adverse action. If the Title VII had applied, then remember the plaintiff would have to show some evidence of age. Then the burden would shift to the employer to show a legitimate reason for what they did. Then the burden would have shifted back to the plaintiff to argue that that legitimate reason was a pretext, and so forth. But it doesn't apply. In age, the plaintiff has the burden of proving that, and the burden shift does not go on.